This channel does not promote any violence, harmful or illegal activities. All content provided by this channel is meant for educational purpose only.
27 minutes.
Gathering 27. Right, item 27, my lord, I made an application for addition of party. I am representing all the untainted
What is your CAN number?
CN1.
1 is there today, but 2 and 3 files.
There are, what I
file
suggest,
আছে।
I have
File আছে নেই। Files are not here because date is
yes,
mentioned.
on this point, there seems to be couple of matters. Now, I am representing for the untainted persons who in the last time they thought they are untainted, they don't have to think anything about their life. Now we have faced it. So once it is decided either way, my lord, we want to say our view because now it's they are seeking to challenge the, my lord, the statute itself, that prior teaching experience 10 marks. At what time it should be given? That's the law point.
No, not at what time. The entire thing is ultra vires.
Well, then fine, entire thing cannot be taken because Supreme Court has affirmed it. But in any
No,
case,
point has been decided. No, not at all.
all I say today that
Not at all.
in the earlier entire proceedings, because I thought I am an honest, I need not be a part of the proceedings. I lost my job. This time, my lord, I am so apprehensive. That's why I have made an application for addition of party. Either way, lord,
All right. What is the application 2 and 3?
lordship may add a skip.
Yes. Addition of party. Untainted candidates addition. You also same thing.
In similar,
You are challenging the rule.
in my case, Milord, there is no classification of tainted, untainted.
All right. Please place your case.
Yes.
The opposition is there.
Pending, my lord. My lord, other
Yes, my lady. My lady, may I just add
so many requisition is pending in same point,
virtually?
and we also
May I
find
just
this
add
addition of
points
party.
here?
But I was
And there is
suggesting,
6 on
yes,
10.
that's the reason I was suggesting.
One matter is there before the court.
Yes.
The council is present. Let us start.
My lady, I'm so sorry to interrupt. May I just place one point here, my lady? I appear also for the untainted.
Yes.
My lady, I also appear for the untainted. We are untainted candidates who've taken the exam successfully. But this issue, my lady, which of this challenge of this rule has been previously decided by the Calcutta High Court by a division bench, my lady,
right.
upholding the rule and security requirement,
Very well.
giving
Yes,
past
please.
experience. So, for
All right.
instance, if you have
My lord, in the
let's take
meantime,
into account.
the copies of the can may be given to us also. I'm not praying for an adjournment, but it may be given to us. My lord, we'll know that who are the applicants.
All right.
This is one can for the commission.
One. Can
And we have received none. State has received none.
Well, according to, I'm sorry.
can one?
No, we have received all.
You've received all. The cans which have not been served upon the parties, please do serve.
Yes, but we may also get a copy so that we know
State can also
that what
be
points
served.
are being taken.
And the board is also there. Board can also be served. All right. Those who have not been served, please do. Yes.
Milord, the point arises, Milord, the background of this, let me tell you, Milord, there was an selection for appointment of teachers in 2016, which was set at not a whole hog by this Honorable High Court, which has been upheld by the Supreme Court. Milord, that's not the issue. Now, the Honorable Supreme Court, Milord, gave them liberty to go for fresh recruitment. Now, in the name of going for fresh recruitment, they have enacted new rules. That rule is under challenge, its virus is under challenge. The virus of these rules was never challenged anywhere before. The court has recorded in division bench, the rules are not being challenged, therefore you are not interfering. Now kindly come to the middle of the rule. That is at page 32.
Yes.
This is of 29th of May 2025.
Why are you challenging it here in November?
No, the petitions are pending before this court for some time.
There are petitions pending, but you have not challenged it.
Yes. No,
Your-
you mean
Yes,
Milord, several persons have not filed this petition challenging the virus of the rule. This is one of such petitions.
In November.
Yes. Anyway, but in November doesn't matter. That the challenging of virus does not depend on the particular time. The kindly sees below what is these rules? These rules are below framed in by virtue of Section 17 of the West Bengal School Service Commission Act 1997. I just take your lordship for prima facie satisfaction few of the provisions. The kindly comes to the provision of a selection of vacancy. This is very important.
Page.
Page 35, Rule 7.
All right. Information regarding vacancies.
Yes. The
Yes.
Commission of School Education shall, on being intimated by the West Bengal Board of Secondary Education, as and when deemed appropriate by the board, prepare a vacancy statement, vacancy statement of assistant teachers.
Hmm.
Therefore, the teachers who are already there, they really are not getting any vacancy for them. And with the approval of the state government, send the same to the board. The board shall, with approval of the state government, send the category wise so and so and so. This is the creation of vacancy for fresh selection. Now, while fresh selection is made, then the parties should be treated, Milord, at level, at par. All the applicants will have the same benefit of getting the getting entry into the service. Immediately, my lord will find that in these rules, they have created a class amongst the class. Kindly come to the schedule. This is the educational qualification, including professional qualifications for selection of assistant teachers. Therefore, the educational qualifications are at the entry point fixed. Now, kindly come to page 42, Schedule 2. Selection to the post of assistant teacher for class 9 and 10 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience. If this is a fresh recruitment for the fresh vacancies, you are inviting the existing teachers to participate, along with the fresh recruits, fresh graduates, fresh entrants. Oral interview and lecture demonstration determined by the Central Commission. Written examination, OMR based 60 marks is common to all. Academics, educational qualification common to all. Then kindly come B, prior teaching experience, 10 marks. Therefore, this 10 marks is additional benefit to a particular group who are also equally applying for entry into the same process. Whether this can be done. This would be apparently and patently in violation of Article 14. And then oral interview and lecture demonstration. Now, lecture demonstration of the persons who are allegedly worked, though illegally, and the appointments were set aside by the Honorable Supreme Court declaring void. Another question would come whether they can be given the benefit of that so-called experience. This prior teaching experience 10 marks would violate the Article 14. You are creating a class among class. Now, this is the values which I am challenging. Herein before, well, I must say, because I had the occasion to appear, petitions were moved by some group where the Honorable Division Bench says, since the rule is not under challenge, we are not interfering, giving certain reasons. Therefore, now the scope of this court, consider the values of the challenge. Is that matter is still pending? And this is the petition where I am challenging basically on this ground that you cannot, at the entry point, create a classification. By that, you are trying to give advantage to the persons whose services were terminated. That's the intention. That you can come through back door. Giving 10 marks means all other new entrants will be out at the very threshold. Whether this can be done. This is the point.
Then, has the list of tainted and untainted candidates been
Not-
published?
According to me, not. According to some, yes. The list which has been
No,
published,
sir.
which I can demonstrate if
Yes,
your permits me from the Supreme Court judgment, is an incomplete list.
All right.
Again, to protect a particular group. But I am not on that. I say that if the rule goes, then whether tainted, untainted, everything should go. At the threshold, everybody should be put on the same level without giving any additional advantage to X, Y, Z. That should be the compliance of Article 14 and 16 of the Constitution.
Show me the direction of the Honorable Supreme
Yes.
Court regarding this.
একটা কপি আছে না না যশ সাহেবকে দিতে হবে
সিঙ্গেল বেঞ্চে প্যারা 12 এই জন্য ডিভিশন বেঞ্চ আর বলেনি, সিঙ্গেল বেঞ্চে প্যারা 12 বলা আছে। যেহেতু একটা করেছে রে ভাই, সবই তো একই ব্যাপার।
Give me the number. It can be put on the screen.
Yes,
Say, officer, the number.
দিয়ে দাও জাজমেন্ট ডেলিভার্ড অন সুপ্রিম কোর্ট হ্যাঁ থার্ড এপ্রিল কেন হার্ড কপি আনো না বলি কথা শুনে এনেছো কোথায় কাজের সময় পাও না এনেছি এটা রিপোর্ট রয়েছে তো এটা
2025 INSC 43
বলো ওদের
2025 INSC 43 দিয়ে দাও 2025 INSC 43
তো করে বলি কাজের সময় ঠিক তৈরি থাকে না খালি মুখে মুখে তৈরি থাকে আইপ্যাড থেকে দেখো না এটা রিপোর্ট হয়েছে তো
হ্যাঁ রিপোর্ট
তাহলে সেটা দিচ্ছ না কেন
2025 INSC 437
My lady, I wish to interrupt. May I just make one point while my friend finds the papers, my lady? That the Supreme Court actually ordered the publication of the tainted and untainted lists.
দাঁড়াও তর্ক করছো কেন
And to publish the list of the
কাম টু দিয়েছো দিয়েছো ওখানে এসছে
Page 35, Rule 7, you mentioned something regarding the vacancy statement of assistant teachers,
Yes.
right? Your submission is that since the teachers are already in service, the post cannot be treated as vacant. But then the entire selection process stood nullified. Then where is the question of,
that's to nullify
yes,
Therefore,
though
they are
the
creating-
seats have to be treated as vacant only.
yes then how could you give
Yes.
additional 10 marks for teaching experience
To that teacher.
this is a post for fresh recruitment fresh graduates at the entry point then you come as a fresh graduate but you cannot have the benefit of 10 marks for teaching experience I am not considering whether this was void or not that means you are creating class among
That I've got.
that
followed.
you cannot do and
That
at the entry point whether there are Supreme
I
Court
have followed
authorities
it. I have followed it.
পেয়েছো দিয়েছো এসবকে well in the meantime may I read out
Yes, please read out.
এই জায়গাটা দেখো
the conclusion of Supreme Court judgment in paragraph 45
এখানটা কমিশনকে একটু বলতে হবে
the last
Page
question
মাঝখানে।
relates to the relief and whether it requires any modification we find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates were appointed must be terminated and they should be required to refund any salaries or payments received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. The next paragraph. For candidates not specifically found to be tainted,
Hmm.
who are claiming to be untainted,
Hmm.
the entire selection process has been rightly declared null and void
Hmm.
due to the egregious violations of illegalities which violated Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled.
31st October.
However, the candidates who are already employed need not be asked to refund or restitute any payments made to them.
সেগুলো কি আছে আমাদের
Their services will be terminated. Further, no candidate can be appointed once their entire examination process results have been declared void. Therefore, the Supreme Court is very categorical that all the appointments having declared void, none of them could be appointed. There is no doubt in it.
All right.
And this bias of the rules was never challenged before.
Hmm.
The division bench of this court said, recorded that since rules are not challenged, we are.
Division benches order, please.
This is
No, no,
division benches order.
division.
The division benches order I have handed over, my lord. Arunima Paul.
Convention is ordered now.
Yes,
Your fifty now.
and
16 July 2025.
10th of July 2025.
so 16 July 2025.
In the matter of
Division bench.
16 July.
Orunima Paul has been placed.
Arunima Pal?
16 July.
It must be the same thing possibly.
Same thing.
16 July.
Same thing. 16th of July. Yes.
No, my lord, just before he,
Let him finish.
no, my lord, the writ petition, in the writ petition from which this appeal arose, my lord, there was a specific prayer, my lord, towards
Challenging
by.
by-
And my lord, it was given up before the honorable single judge.
Whatever.
Let us-
Yes, you
let us
will
not-
get a chance.
Let us
Yes.
not go by the judgment of the court.
Yes.
Kindly come to page 24.
Yes.
Well,
Division bench.
Line from the-
We order to
Yes.
continue.
The recruitment rules 2025 has not been challenged by any of the appellants.
Hmm.
In that background, the division bench order comes.
Hmm.
But I know this specifically because I had the privilege of appearing before the division bench and
Yes.
Supreme Court as well.
बाकी है देना.
And then this order was appealed from Supreme Court, did not interfere.
All right.
But the point of why this challenge remains wide open.
All right.
And that's now I'm being conversing before your lordship.
All right. This is all? Yes, commission. It is your
Commission.
rule that has been
State
challenged.
rule.
By rule, my
The
lord.
state rule. All right.
Yes, my lord.
Yes, state.
My lord, I'll start by submitting that, my lord, the learned advocate general has not been served, but I understand the bench wants to, my lord, look into the matter, my lord. So I'll address your lordship, my lord.
Please do.
My lord,
সেটা দেখিয়ে দাও।
Lord, the petitioner essentially is challenging the granting of the marks for the prior teaching experience. That is the long and short of the submission.
Yes.
Now, my lord, first your lordship kindly will take, my lord, the other batch of writ petition which was taken. If I may point out a singular paragraph of this honorable single judge's order, which thereafter traveled before the honorable division bench.
Court's order I have handed over.
My lord, the single bench I'm handing over. The same, Arunima Pal. Yes. Single bench for now.
Just give 2 minutes. আস্তে আস্তে কর, আস্তে আস্তে কর।
Now, my lord, yeah, my lord, we have the copy of Arunima Pal writ petition also, para 12. We have the copy of the writ petition also, which clearly says in the prayer that the various of the rules were under challenge.
But then the division bench is.
I'll say why this is coming. I'll say why this is coming. Can you take paragraph 12?
Yes.
Learned senior advocate representing other groups of petitioners at the threshold has submitted that prayer B of the writ petition being WPA 13457 is not pressed, wherein declaration is sought for to the extent that the declaring the rules of 2025 and the recruitment notification dated 30th May 2025 ultra-virus. Jamala, that prayer was given up. That is why the honorable single judge did not decide the virus, and that is from where, my lord, this submission is coming. Now kindly take the division bench's order. First, my lord, kindly take paragraph 28.
Yes.
In reply, Mr. Bikash Ranjan Bhattacharya, learned senior counsel, has submitted that the writ petitioners are not challenging the virus of the recruitment rules 2025, as their rights as untainted candidates are fully secured and has to be tested on the anvil of the judgment of the honorable division bench in paragraph 363 Roman 11 read with paragraph 49 of the judgment of the honorable Supreme Court. Now can I take the prayer of Arunima Pal? Give the prayer of Arunima Pal.
I'll give you.
But I am giving a soft copy, my lord. Kindly pardon me, my lord. This is the prayer of Arunima Pal,
All right. What is
where
the
the virus was under check. I'll read, my lord. Prayer B said that in Arunima Pal, a writ of and or in the nature of declaration declaring that the Kolkata Gazette dated 29th May 2025 issued by the Office of the Principal Secretary of the Government of West Bengal and the notification dated 30th May 2025 issued by the Commission as being ultra vires to the Constitution of India. Now, my lord, this I believe is also filed from the same chamber that I find from the advocate on record's name, my lord. So, my lord, they are well aware that the virus was under challenge and it was given up by the before the honorable single judge. Though the submission, no, it's about being aware whether there are averments or not. Now, my lord kindly takes the constitutionality, whether the state was empowered to introduce 10 marks prior teaching experience or not. Now, my lord kindly takes paragraph 34 of the judgment. Division bench, page 22.
Yes.
The awarding of 10 marks is an weightage to be given on the basis of the experience, and it is only expected that in a selection process of this nature and kind, all the candidates are required to undergo the rigors of the selection process. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks be given to such candidates is not arbitrary. The object is to select and appoint experienced teacher, as rightly pointed out by the learned Advocate General and the learned Senior Counsel appearing on behalf of the Commission. The appellants, writ petitioners are not coming within the purview of the category in whose favor the benefits and concessions has been extended in paragraph 49 of the judgment of the Honorable Supreme Court. They are not candidates selected in the 2016 recruitment process. In the meantime, they have not also applied for the service in any educational institute. Then kindly skips over a few lines to the next page from the third line. If we accept the submission of Bikas Ranjan Bhattacharya, learned senior advocate, then for the selection for the same subject, teachers, two different eligibility criteria has to be applied. The eligibility criteria in the selection process of 2016 is different from the recruitment process of 2025. The rules are more stringent and student-centric. The revision of the eligibility criteria, so and so, then the NCT, that NCT also allows it, is discussed. Then Malad kindly takes towards the bottom of that page, second last line. While the candidates with 45% marks in graduation may be eligible for the same subject a candidate requires to apply under the recruitment rules of 2025 would have to fulfill a criteria of 50%, and both of them, if appointed, may be a teacher for the same subject teaching in different education institutes. This will result in discrimination and a compromise of the quality. The prior teaching experience is an important factor, as experienced teachers may impart education for effectively and efficiently. The recruitment rules 2025 has not been challenged by any of the appellant. The delay, but this is where, that is why the single judge's paragraph was important. They prayed for it but gave it up. The delay in the recruitment, fresh recruitment, is due to the pending litigations, and when the opportunity for employment is opened by advertisement, it is always open for the authority to decide the eligibility of the other criteria in the academic interest for the benefit of the student. We accept the submission on behalf of the state respondent that there is no specific direction in the order of the Honorable Supreme Court by which the state is obligated only to fill up the declared vacancies of the first SLST 2016. All the orders relating to the issue had directed the fresh recruitment to be carried so and so. Then Malad kindly skips over to the next paragraph. If the government, 35, if the government felt that the experience gained by the candidates is relevant, the court cannot take a different view in judicial review. Similarly, prescribing any age limit for the given post and also deciding to the extent to which any relaxation can be given to the said age limit are essentially so and so. But these are on the other points which has been discussed. Then I am skipping over a few lines. Any process which applied equally to all the candidates and was designed to garner the best talent cannot be called arbitrary or irrational. The eligibility criterion in the recruitment rules 2025 is in furtherance to the object of finding the best available talent. The prior teaching experience has been considered by the division bench. It has been held that we are empowered to introduce it, and it is held that the court should not interfere in judicial review when the administration has thought it to be a fit exercise of their discretion, administrative policy. This point, I need not elaborate whether the prayer was there or not, whether it was given up or not. It was prayed, it was given up. As far as the state is concerned, it is issue estoppel. This point has been decided. This order has traveled before the Supreme Court. We are placed in several matters, and all the points are discussed here together because there were many other challenges by several petitioners, my lord. All my learned seniors, my lord, assisted the Honorable Supreme Court. My lord, your lordship, my lord, even assuming that there was no challenge, it's a fresh challenge, fresh batch, who is, my lord, ultimately, what is the point? The point is, first of all, whether I had the power or not. Secondly, whether it's ultra-vires the constitutional scheme, whether it's creating arbitrariness is or not. But the power has been upheld by the division bench, then the Supreme Court, and the fact that it is not arbitrary, within the campus of Article 14, that has also been discussed. But Supreme Court, I can copy it.
The Supreme,
I won't take soft copies.
no, my lord. Bolo, she's-
Yes.
Therefore, my lord, this point, my lord, your lordship will kindly, my lord, not go into, my lord, any further.
Yes.
Your lordship will not hear
But
the
may I?
I will, certainly I will hear.
May
I
I
will
add one
take you.
point to the government?
Yes.
My
My
lord,
lords, may I assist my lady, my lords, by just making 2 or 3 points, my lords, if I may?
Just wait, madam.
Yes, very well.
Paragraph 6, page 4 of this judgment, which may have been placed, could have been placed. Paragraph 6. My learned friend Mr. Vikas Ranjan Bhattacharya appeared and what he argued. Mr. Bhattacharya submitted the finding, observation, directions, above order to be strictly followed. That's all right. Mr. Bhattacharya further submitted notification, etc. Then may come. Further submitted that there has been significant change in the rules which would render the present applicant disqualified. It is submitted the prior teaching experience for 10 years was not an eligibility criteria in the earlier notification. Moreover, the percentage mark has been given arbitrarily and otherwise qualified. So these are specifically argued. Please, may not see by Mr. Bhattacharya further argument. Please come to me at paragraph 24 of this judgment. Page 15. Mr. Bandopadhyay, with the argument of the government,
Commission.
a commission was justified in awarding, has justified the awarding of 10 marks for prior teaching experience on the ground that it also extended to the teachers who have taught in said schools under Kendriya Vidyalaya Sanghan, etc. and training and other government-sponsored schools. Marks for prior teaching have been provided with a view to appointing experienced teachers who will be able to teach. Pausing here, my lord. Now, what you argued here, because this teaching experience marks, 10 marks, are being given only to those unsuccessful candidates who have failed. It is not so. The teaching experience 10 marks are available to everybody. Even the client applicant,
September order
if he has got teaching experience in other schools, etc.
September
he
order
can
এদেরকে
get
কন্টিনিউ করতে বলেছে
not a class within class.
আমার পোস্টটা যে
See,
ভ্যাকেন্ট
without the point, see, the teaching will be given to all who have, not necessarily those who have appeared in the earlier first stage and failed. No.
পয়েন্টটা এমনি কোনো জোর নেই
But basis is no.
পয়েন্টটা
It is not confined to the candidates who had succeeded in the earlier first and thereafter been disqualified because of others' fault. It will be available to all. It is made clear.
But
And
why will the freshers lose this 10 marks? Why will the freshers lose this 10 marks?
the freshers, if they're teaching experience and applicants of other schools, they will also get
No. Freshers. Fresh candidates
candidates.
not having experience. Why will they lose this opportunity?
There were best candidates. If they have teaching experience, they can get
Those who have got teaching experience are not fresh ones.
experience. Why should they include it? That is, is the teaching experience that's what is being argued by Paragraph 24. The teaching experience have been taught in school under Kendra, Vidya, etc. Marks for prior teaching have been provided with appointing experienced teachers. That were experienced teachers, they will get the eligible appointments. What's wrong there?
Why will the fresh candidates not be, or rather lose this 10 marks?
No,
This has been answered.
why don't you? Because teaching experience is a valuable qualification.
Yes.
Now, all the applicants can avail of this, provided he has no teaching experience. Now, is it argued that this qualification mark of 10, given for teaching experience, is bad? Or why it is bad? Why it is bad? Can you see paragraph 35?
34.
Of the judgment?
34 also, sir. 34 has answered the point.
35 of the judgment. And what the court said.
34 fourth line answers.
If the government failed, that is similar paragraph. If the government failed, that the experience gained by the candidates is relevant. A court
কোনোটাই hard
cannot
copy আনিস
take
নি
a
তোরা।
different view in judicial review.
আরে বুঝেছি কিন্তু তোদের এটা ধরে চললে তো হবে না, সবকটা কনসিডার বিপদ হয়ে যাবে।
Over exception, that is all done by expert body. That is also mentioned in the document that these criteria have been fixed by expert body. And why the second interpret with them? Now, Myla asked a question, or then, but I'm happy in Myla. So why 10 months are these will be given for experienced teacher? Answer is that government values experience. And those candidates who have got teaching experience, they should be awarded by diploma. Because you get a teaching experience. That is what was argued. And not can you not come to the paragraph? This is if it has been taken the point, can the court say court cannot take a different view in judicial review? If the court say if the employer thinks that the teaching experience is a valuable asset for which can be rewarded. It is why it is arbitrary. It is open to all. It is not that had there been teaching experience of only the first level failed should have been given. No. It's just not. Anybody can speak. That people who have got no teaching experience they have done. People who have got teaching experience they are also going to do that. Some people have now these people with full knowledge of this qualification and station mark have applied for and participated in examination already. Doesn't know that? They have appeared, participated in the examination held in September. Appeared and with full knowledge. Now after having appeared, they are saying that you can just candidate just Mr. Data তোমরা on the petition I go without copy
My lords,
I'll show you a document
My lord.
of Supreme Court. They have appeared, participated, everything with knowledge of this. At the time of appearance or the application, they have not taken any objection to this rule, knowing that they don't have teaching experience. Try whether I get it. Because the judgment that a large and cited of Supreme Court that was modified by that of Supreme Court. I said that has not been in the judgment 17th April. Kindly see that 17th April. Order. Or Supreme. Kindly see. Then I will give you a list of dates. See that what
Order.
Supreme Court changed the view. And
my lord will kind.
he may not in this case, Supreme Court accepted the prayer. The judgment cited by Mr. Subjective was earlier done.
Yes.
Client accept the prayer made in the present application. In further, it relates to assess the details or process and and not found to be date. Subject to the following conditions. First of all, it is all triggered by Supreme Court and Supreme Court is a timetable also. And at the same time, for the fresh recruitment, that forth shall be published before 31st May 2025. Second is very important. Examination and the entire recruitment process shall be completed by 31st December 2020. It's the next paragraph. State government, applicant, appellant, West Bengal, etc. shall file affidavit by 31st May 2025. enclosing therewith a copy of the advertisement for the place recruitment as well as schedule therefore, so as to ensure compliance of the complete recruitment process. In case advertisement is not submitted, consequences follow. We likewise order General Minister conferring an special act on anybody. That's the point. You don't confer special act on anybody. The deputy will be special right. That's what it is. As in conferring a right to an untainted candidate to appear and only a government doesn't confer any special right upon them. The same right the best candidate also has. What is the right they don't have? The question of right to apply is different from the qualification marks of it. Criteria for that. They are the same right to apply. Had the order said that only untended candidates will appear and nobody else, then Mr. Bhattacharya could have said no special right will be given to anybody. No matter as fresh recruitment process is concerned, no matter anybody can apply. This application is not confined to untainted, it's confined to fresh candidates also. But what the order of Supreme Court, what does it get? The fresh candidates will get some advantage. That even though they have no teaching experience, they will get 10 marks. What is this argument now? After we got kindly, this is timetable, everything scheduled by Supreme Court. Taken back to Supreme Court. Now, we not after appearing, I will take back this topic. So, give me some. Yeah. Copy আমার কাছে আছে
আপনি করুন স্যার আমরা দিয়ে দিচ্ছি
Can you take a list of the similar all these relevant facts which should be rejected outright? কোথায় গেল আমার
আপনারটা কোথায় গেল?
কোথায় গেল দেখুন 29th May, 17th that the order was passed to publish the written by 31st May. 29th May applications to the entire. Publish the rules. That is publish the rules called the website etc. for appointment to the post or as assistant teacher appointed etc. and physical. This is that can be equal page. Number is given there. 30th of May 2025, notice issued inviting application for conducting second for the classes 11 to 12 also. In the pursuant to the judgment dated 3rd April passed by the Honorable Supreme Court, stating that the said selection process shall be governed inter alia by the rules 2025. Relevant acts and subsequent amendments. Noted that the recruitment process started on 30th of May. Can you see that notice where specifically mentioned that Rule 225 will apply? They have seen that notice and pursuant to that they have applied. That please see the notice which is annexed. There is it is shown. I'll show it to you, Lordship. Let me finish the list of dates and show it to you, Lordship. Then 16th June. Online application for appearance in written
annual day and meeting signed up, otherwise
in 14th July, last date of receiving the online application as per schedule, etc. Then 7th July, Rule 25 governing second was challenged on the ground that 10 marks for teaching experience should not be granted, and the same was dismissed by the Honorable Single Bench on 7th July. That order of should not seen. Mr. Bikajan Bhattacharya argued, he knows better, is argued noted, he was arguing that giving 10 marks for teaching experience is bad. Same arbitrary void, etc. That I must again point out, because Single Bench dismissed the petition, men are on the ground, another ground was the untainted candidates, tainted candidates should also be allowed to appear in the second examination. But court held, Supreme Court said only the untainted appear. So because no, they said right, only that prohibition of tainted candidates should remain valid. And not on that ground, it is dismissed. Single bench has not specifically given reason why this 10% except his influence is good or bad. Right. From that, they come to the division bench appeal, which has been placed before Lordship. 16 July, writ petitioner being aggrieved by the judgment filed an appeal before division bench, which was also dismissed after hearing the parties, initially observing that awarding of 10 marks on the basis of experience is not arbitrary. That paragraph was shown, I can prove everything. Then Milord, special SLP was filed. We have got a copy, keep the copy ready. SLP was filed. Same was dismissed by the Honorable Supreme Court, not by with reasons. With reasons. After observing, we find no good ground and reason to interfere with the impugned judgment of the High Court. Can you see the judgment? A Supreme Court, a dismissed college, SLP dismissed. We got a copy, I'm handing what a copy to your lordship. You ready, good? And with this, we're quoting from that judgment. This is the handing. Mr. Bhattacharya appeared. He knows this better than me.
Therefore, I know better.
I know better than me.
Unfortunately,
That this had happened. You know that this had happened.
I know what is happening and what is going to happen.
Not what
Anyway.
is going to happen.
Oh, he knows what is going to happen.
With reasons they have been dictated. Then McAllis list of this serial number 7 only come to. Lead petitioner Bhim Kumar Sarkar received his admit card issued by the commission for examination to be held on 14/9. Can you see page 31 of the lead petition? The document is annexed in the lead petition. Page 31. No, I'll show later. Page 31 lead petition করে এইগুলো আমার সামনে রেখেছে কেন এত সব আমার পিটিশন এইগুলো সরার lead petition page 31 দেখো আমারটা কোথায় গেল আমার বিপ থেকে হারিয়ে গেল It is mentioned below for particular examination date is mentioned. Admit card is for that date. And that was for class assistant teacher 11 and 12. That also mentioned. আমাকে না দিলে ভাই বিপ কোন হারিয়ে ফেলে কি করে দেবো বল
Yes, then
হ্যাঁ
I have seen.
Then Milord, he appeared in examination 14/9 with full knowledge and you can go down. No. Then mechanism next date. 22nd August. Notice, Milord, can omit D. Notice was issued by the commission permitting the selected and appointed untainted, but not typing mistake, can you make it untainted, not untainted. The spelling mistake. Candidates, another 10 days, time was being extended for submitting application. Extended. After Supreme Court order. Then Milord, 9, serial number 9. 7/9/25, written examination for the assistant teachers held, of 9 and 10 held. And on 14th September, this is important, a file for the assistant teachers for 11 and 12 was held. And in this petition appeared. Here and got the admit card for that. Read petition ready. Now, read petition, then 14th September, petitioner Bhim Kumar had taken the written examination on the said date and result was awaited. Now, on 31st October, pending that, he made this writ application. And what is first prayer? See the prayer? 10%. In the same present petition, have filed a petition challenging Rule 25 on the ground that teaching experience of 10 marks cannot be awarded to the selected untainted candidates. See the prayer A, or the writ petition. That is the ground he has taken. Prayer A. On that ground, cancel. And this has been division bench judgment shared in the face, which has been approved by Supreme Court by giving reasons. And in spite of that, 2 points arises, Milord. Can this petition be allowed to be moved when prima facie there is no case and this order is of division bench judgment is binding on everyone, which is approved by Supreme Court. Therefore, no case prima facie case is made up. Therefore,
Yes.
take it into account that single bench may be pleased to say, what can I do? I have good deal of sympathy, but I'm bound by judgment of division bench approved by Supreme Court. Second point, the time schedule and this selection process for untainted candidates, etc., has been triggered and fixed by Supreme Court order. Supreme Court has fixed a date. The 31st May is the date by which you must issue the notice inviting applications. And further, that process must be completed by 31st December 20. In the middle of that, on 30th October coming, can this selection process after having started, can that be interfered with at this stage? And the time is fixed by Supreme Court. It will delay the selection process.
Yes.
Similar, this is the now it is matter which is in the domain of Supreme Court. They are now getting interfered by the Honorable High Court. Just to minute, in my humble submission, in by stricture of Supreme Court. It will matter if order is passed, any interim order is made, then that will affect the progress. Secondly, thirdly, I point out, it's about minor discussion, well settled principle. When the recruitment process has started, and on the basis of rules which are known to the appearing petitioner, and on the basis of which he has applied, without mentioning that I'm making the application without prejudice to my right to challenge, etc. Can he, after examination, when results are to be published immediately, very soon, the commission can take a look. Can it be allowed, should be entertained by the court at all? This is my first submission. In the court, in its discretion, should be particularly in view of the fact that the matter is fixed by Supreme Court. And they should apply to Supreme Court then, that kindly similar the notice of recruitment notice of recruitment. Notice of recruitment, that notice here, I taken out. No. Lordship in the notice is clearly mentioned, which are quoted in the list of dates, that it is Rule 2025 will apply. Please similar the part.
Yes, Rule 25 will apply. 25.
Now, Milord, what has been the, apart from on merits also, Milord, no ground has been disclosed. Why this additional teaching experience mark, a particular mark, 10 or 5, whatever maybe, for a particular kind of experience, teaching experience, which is a valuable asset of the candidate, cannot be given. Fixed by expert body, and division bench said that if they have fixed it, nobody has, can you see, they have not argued that teaching experience is irrelevant matter for the appointment of teachers. If the argument could not be made and has not been made, the teaching experience is an irrelevant consideration for appointment of teachers. I humbly submit, nobody can argue that teaching experience is irrelevant consideration for teaching. For teachers, is not appointing football players. There I could say the teaching experience 10 months will be given to a football player for being appointed in the team. It is being given to teachers. And teaching experience is valuable qualification. That experience. So, this petition will be nipped in the bud. It should not be without entertained at all.
Did I hear you?
Yes.
You?
Yes.
All right.
My lord, there are couple of points which have been taken and that was identical, so I won't be touching the same. All points by Mr. Mitro, my lord. In fact, I also had in my mind, I'm not touching. First, I would address on a very fundamental point of view. Mr. Bhattacharya, in my understanding, is trying to portray a picture of the world where either there black exists or the white exists. In other words, I said metaphorically this part. In other words, the word void, null and void in the Supreme Court's order, it's so clear, so watertight that it cannot be tweaked. Either Supreme Court having declared null and void, does it mean that Supreme Court has also said whatever is also attached with the all the candidates minus the tainted? Because well, I'm not appearing for the tainted, so tainted it's done. Kindly look at from this point of view. I do not say that in a particular situations the court cannot declare something to be void, null and void, and the consequence of the same means absolute zero, no experience out of it. It can be. But contrast it with the situations, having said null and void, the same Honorable Supreme Court also said and felt for us, in a sense, saying that who were working somewhere else, they will also be able to resume their duty, number one. In other case, Lordship, kindly take paragraph number 47. Lordship will see the meat path being taken by the Honorable Supreme Court. It's not black or white. Yes, selection process has been found to be illegal, right? Does it necessarily mean that all the fair candidates who have put in labor, who have received money, and who have also, my lord, whatever experience they had, who have done the teaching experiences, does it automatically go from their experience? To that effect, there is a clear answer by the Honorable Supreme Court in paragraph 47. My lord, the copy is there, possibly with your lordships. Kindly take 47.
Supreme Court judgment is not here.
It is.
Yes.
আচ্ছা দেখি।
That's the main judgment. Mr. Bhattacharya has read out 45. So I am not reading 45. Now kindly see 47. That is the tweak and that's the middle path. And recognition of, I may not use the word sympathy, but that what we suffered is a collateral damage. We are